So many times we are being unfairly terminated, unfairly dismissed by our bosses. We are being publicly humiliated and your boss just lays you off and says, I don't owe you a reason, I don't owe you an explanation. Well, in today's video, I'm going to give you the exact procedure under which you can take to be able to get justice for someone unfairly terminating you from your job that you've been working for 10 years, 15 years, 20 years. So in today's video, let's discuss what to do if you've been unfairly terminated, what is the exact procedure, and what is the time period under which you can be able to get justice for being unfairly terminated. So welcome Simply Legal, and let's get right to it. Welcome back to Simply Legal. My name is Kahuma, the usual host on this channel. And before we even go right into the video, please hit the subscribe button, hit the notification bell, and most importantly, share all these videos with everyone who you know would love legal content simplified for them and current events broken down for you. At the same time, please go onto my legal mobile app called Farmeron. Farmeron is an app that provides legal services for you that is going to help you with whatever legal issue you have. Farmeron is available on both Android and Apple Play Store, where we have over 30 plus lawyers that will help you with whatever legal challenge that you have. Remember, it's available on both Play Store and Apple Store. Let's get straight to the point. Now, according to Section 71 of the Employment Act of Uganda 2006, it clearly states that any person who has been in active employment or who has been employed by an employer for more than 13 weeks, that is about, let's say, 2 or 3 months, is within time to complain if they have been unfairly terminated. But let's go back to the actual definition of unfair termination. Unfair termination is where your boss or someone who you have been working for fires you unlawfully without even giving you a fair hearing, without giving you a fair trial or a reason as to why they're terminating you. So therefore, unfair termination is that even in the given sense that it was unfair from the start, this person did not give you a chance to explain why they're firing you, what you've done, what are the reasons for firing you. So according to Section 71, it states that you are, from the date that they fired you, let's say there is 1st February, from the date when they have actually fired you, you are within a period of 3 months to be able to go and report this issue to the labor office. Now, many of you may not know what a labor office is. I want to just empower you employees, because I know the majority of people I'm speaking to. An employee has rights that can actually get you a very huge turnover or a lot of costs and damages in case anything ever happens to you. Now, if you have been fired on 1st February, if you take more than 3 months, meaning that you're missing the window period for when you can be able to go and report the unfair termination. Now, I want to advise you, the moment you are unfairly terminated, if you are unfairly terminated in January 1st, then you only have about up to April for you to go and report your case. The moment it reaches April, you're giving the employer's lawyer a chance to be able to tell the judge that, you know what, this employee, according to the employment law, was given 3 months to go and report this issue. Why have they taken so long? They're now just coming at this point to ask for damages, but then they're past the window period. So I wanted to explain to you the fact that you can be able to get retribution, you can be able to get justice in terms of that window period of 3 months. Remember, this can only apply when you have been working for this employer for a good amount of time. That's about 12 weeks, which is about 3 months. So let us now go to the actual procedure that you can take once you have been unfairly terminated, even before you consult your lawyer. So let's go. So the first procedure is that the moment you have been unfairly terminated, like I already said earlier, it is always important for you to file a complaint in the labor office. Most of the labor offices are found at places like, let's say, KCCA. You can also actually file a complaint, or you can actually start building up your case with a lawyer. In most cases, your lawyer is going to advise you that, you know what, since this is an employment issue, we want to deal with your employer in the best way possible. So let us first start with arbitration. Let's start with out-of-court remedies, such as arbitration, mediation. I think I've discussed all of these in previous videos, and I'm going to leave the links in the description below. However, when you are discussing these pertinent issues with your former employer that, you know what, you unfairly terminated me without giving me a reason, your lawyer will go back to what the law says. Now, upon filing that complaint, he will then move on to the alternative dispute resolutions. That's before court. If within that 3-month period, like I gave you an example of them firing you in 1st February, and then let's say by the end of April nothing has come up, then your lawyer can actually say, you know what, I think let's actually take these people to court. So start with a formal complaint with your lawyer, go and file it in the labor office. The labor office in most cases, or let's say offices in Ministry of Gender, are going to provide someone who is going to try and mediate with you, try and arbitrate with you. If they're not finding a solution, then you just have to go to court. Now, a very important point to note is that these this kind of clause under Section 71 of the Employment Act clearly states that you do not have a right to complain if your contract was under probation. Now, what is probation? Probation basically means that if I'm your employer, I will tell you that, you know what, maybe Francis, I'm hiring you for a period of 6 months probation or 3 months. Probationary periods are a trial period. I'm hiring you just to see how you work, just to see what kind of person you are. Do you love working? Can you handle pressure under harsh environment? Can you handle me maybe shouting at you if I'm rude? So I want to see what kind of person you are, what kind of employee am I bringing on board into my company or my law firm or whatever it is. So probationary period does not count for you saying that you're unfairly terminated, because we already agreed when I was writing a contract with you that this contract will run from January 1st to June 30th. If you have impressed me by June 30th, then I'm going to give you a more permanent contract. So, meaning that you cannot take an employer to court for unfair termination if that person had a contract with you under probation. So, let's go to the other procedures and let's see what exactly court will do. If at all you have been unfairly terminated, then we can wrap up with this video. So, before we even look at the various court procedures, I just want to bring to you the principles of natural justice, and these are stipulated under Article 28 of the Constitution of the Republic of Uganda, 1995. Now, I think I've used so many technical terms, but basically, there is a law inside the Constitution which provides for a fair hearing. Now, these are what are called principles of natural justice. The moment you feel like you have been unfairly terminated without that person giving you any reason, let's say that person dismissed you unfairly and in a very humiliating way, you're supposed to present your take on why you believe that you should stay in the company. So like I said, the first situation is please file a complaint in a labor office or under Ministry of Gender with your lawyer. Your lawyer already knows what to draft, how to draft it, and when to draft whatever pleadings or whatever documents he will need in court. Now, like I already said, if arbitration and mediation fail, then your lawyer will then go to court and actually fight for your rights, because you have a right to a fair hearing. Now, under Article 28 of the Constitution, it allows you to tell the judge that, you know what, first of all, every company must have a human resource manual. At least the big companies have them, but there must be some sort of process for why you're firing this person. That is stipulated under the termination clause in the Employment Act. So to simplify everything, if your employer wants to do things the right way, there is an actual way to terminate you without doing it unfairly. Now, if they did not follow that procedure, especially stipulated under the human resource manual of that company or under the Employment Act, then it is important for you to tell the judge that I was unfairly terminated. I didn't have a chance to prepare my defense. I was not given a chance to appear before disciplinary committee. I was not even given warning letters. I was not given any fair hearing or any warning. Then your lawyer will be able to pick up all of that evidence, and then they'll be able to represent you in court very well. Now, what are the circumstances under which the judge handle your matter? Now, in cases of unfair termination under Section 71 of the Employment Act 2006, it basically states that the judge will do either one of four things. Number one, the judge will ask you, what do you want as an employee who was unfairly terminated? So number one, they'll either give you costs and damages, meaning they will ask the employer, if they have found that the employer indeed terminated you unfairly and they have not given you any fair warning, then the judge is going to ask the employer to give you damages in form of money. If they will have to calculate how big was your contract. Was your contract running for 5 years? Was it running for 10 years or 2 years? Now, unfair termination is basically in the fact that they cut your contract short even if you had a contract. So the judge will have to ask your employer to compute what your salary was, and then to be able to get the amount of salary from when you were unfairly terminated up to the end of when you were supposed to finish up your contract. Let's say your contract was for 5 years and you are terminated after 2 years. So they have to pay you for all the 5-year period. If they find that number one, you are innocent, you're not given a fair hearing, and to make matters worse, you did not have time to appear before disciplinary committee. So the judge will give you costs and damages in form of your salary, and also give you other damages because the interest was arising, and to make it even worse, the employer did not employ any methods on how to employ you back into the company. So that's number one. They'll either give you costs and damages, or number two, they'll ask you, do you want to be reinstated into the company? But in most cases, most employees, by the time they leave the company, they don't want to go back to that company because already there's bad blood between them and the employer, or there's bad blood between them and employees who had a bad heart. In Uganda, we call it fitina. If your fellow employees were the ones that led to your sacking, let's say they went and told the boss boss that, you know what, this person doesn't work, he's always late, he's never on time, he doesn't deliver work, he's incompetent, you wouldn't want to go back into such a work environment. So it's always better not to be put into that company back, and it's always better not to be reinstated because you already have bad blood between the boss. So the best situation I'd advise you on after this procedure I've given you is to ask for your cost and damages and the salary that was owed to you, and then just go and work at your own time. Just go and look for another job, look for business, go and do something that will make you more fulfilled. So I wanted to explain everything to you. Thank you everyone for listening to me. And my name is truly Terry Kahuma. Please hit the subscribe button, hit the notification bell, and most importantly, as employees, now I'm mostly speaking to you, please do not ever sit on your right. The Employment Act is there, the Constitution is there for you. Do not ever sit back and let an employer step on you, because you have right. You have a way of fighting these decisions in the courts of law. And until next time, I'll see you. Also, employers, please do not avoid lawsuits by not unfairly terminating people, because you're going to face numerous lawsuits. Well, until next time, I'll see you. Please hit the subscribe button, hit the notification bell, and if there's anything you want me to talk about in a future video, please let me know. And until next time, I'll see you. Bye.